Hi everyone, my name is WIKUS. I'm a Director of Awesome at Lewies Attorneys. Today I'm going to have a brief discussion on labour law and specifically the thorn in our sides, dismissal and misconduct. For a dismissal for misconduct to be fair, you must follow a fair procedure and it must be for a fair reason. Now the Labour Relations Act and the Code of Good Practice for Dismissal requires an employer to follow progressive disciplinary steps, and that entails giving verbal warnings, written warnings, and then final written warnings for serious offences. If the offences justify a dismissal of such a serious nature, the employer should follow a formal procedure to dismiss the employee with a disciplinary inquiry. Before the disciplinary inquiry can start, you must give your employee a written notice that must be signed by the employee to confirm that he knows about the hearing, and if the employee does not want to sign or refuses to sign, any other person can sign as witness to show that the employee has actually received the notice. Now, if we go into a bit of details for the notice itself, it must specify the date and time of the hearing and also the charges against the employee in sufficient detail to allow the employee to prepare for the hearing. The notice must also give certain rights for the employee, which include right to representation and right to state his case. If we go to the right to representation, an employee can only be represented by either a co-employee or a shop steward. Very few companies allow for third-party or external persons to represent employees. Once the hearing actually starts, it will be in the hands of the chairman of the hearing. The chairman must preferably be an independent person that wasn't involved in investigating the complaints and preferably also not an employee of the company itself. When the hearing starts, the employee must be read his rights as they are stated on the notice and must also be informed again of the charges against him, and both must be explained to the employee. The most crucial, or the two crucial rights of an employee is the right to be represented at the hearing and the right to state his case. The representation we've already discussed, and the right to state his case includes that the employee is entitled to ask questions or put statements to the company or to the company's witnesses, and then to give his full version of events. Once the Commissioner has decided that the employee has been properly informed of his rights, that he is at the hearing and that he has stated his case, the Commissioner must then decide on a sanction to impose on the employee. If the Commissioner decides that the employee should be dismissed, the Code of Good Practice states three things that the Commissioner must take into account. One of which is the seriousness of the offence, if the employee actually broke a rule, and if the rule was valid and if the employee knew or ought to have known about the rule. If the Commissioner decides that those requirements have been met and he is now contemplating dismissing the employee, he must take into account the employee's personal circumstances, the circumstances of the offence, and if the employer has consistently applied the same rule to each employee. One of the most important things in any disciplinary process is that the employer must consistently follow its own rules, and each employee must be treated exactly the same as any other employees for the same rules. Should you require any additional information or any assistance, go to our website www.lewies.co.za, look up any of our superheroes, give us a call, and we'll gladly assist you.